For Pascoe Vale.
Thank you, Acting Speaker. I rise to speak in support of the Bail Amendment Bill 2023. And in doing so, I would like to acknowledge the Attorney-General, the Minister for Corrections and the Minister for Police and their respective teams for their work and efforts on putting together this bill. Acting Speaker, Victoria's current bail laws do not properly distinguish between low-level, non-violent offending and serious offending that poses a risk to community safety. This has led to an increase in remand, particularly for repeat offenders who may not pose a risk to community safety. Essentially, this bill is about balance, proportionality and safety, both for the wider community and for alleged and vulnerable low-level offenders. The bill introduces a suite of changes to the Bail Act of 1977 to ensure our bail laws protect the whole community and better target the use of remand to cases where it is necessary to prevent an unacceptable risk to community safety. The bill incorporates learnings and improvements to bail reforms that were previously introduced in 2013 and 2017 by the Victorian Government. Acting Speaker, Victoria's bail system fundamentally operates to allow people charged with an offence to apply to be released from custody until their case is heard in court in accordance with the presumption of innocence. Whether or not a person is granted bail depends on whether the applicable test for granting bail has been satisfied and includes the unacceptable risk test, the show compelling risk test and the exceptional circumstances test. If bail is refused, a person is remanded in custody for this period. When bail is granted to an individual, conditions that are set by the court must be followed, and these can include, for example, that the accused person will agree to come to court when their case is scheduled to be held, not contacting witnesses, reporting regularly to police is the other measure. Where bail is not granted to an individual and they are incarcerated in the period up to their court case, this time may count towards any prison sentence imposed by the court. An accused person should be held in a separate area of detention from persons who have been convicted of an offence is another requirement. However, through the reforms that were introduced in 2013 and 2017, respectively, as a result of the two tragic and devastating crimes, Victoria currently now has the most stringent bail laws in the country. And these included, in 2013, following the tragic murder of Jill Marr on Hope Street in Brunswick, just south of my electorate, at the hands of an evil and violent male offender who was on bail at the time. The Bail Act was amended to introduce new bail offences, being committing an indictable offence while on bail and contravening a conduct condition of bail. In 2017, following the Burke Street tragedy where 6 people were killed and approximately 30 injured, the Victorian Government asked the Honourable Paul Coghlan QC to undertake an urgent review of Victoria's bail laws with the aim of further increasing community safety and restoring the public's trust in the bail and justice systems. The subsequent legislative changes made Victoria's bail laws, again, the toughest in the country, including by making it more difficult for repeat offenders to get bail, and included removing the presumption in favour of bail from specific offences and enabling an uplift in bail tests for people who were charged with reoffending while on bail. This meant that people would face more onerous bail tests intended for more serious offences when committing repeated low-level offences. When combined, these 2013 and 2017 changes were intended to ensure that offending on bail would have increased consequences for breaching bail requirements and were designed to restore public confidence in the system. However, the changes which came into effect in 2018 resulted in a significant increase in remand numbers and the significant increase in remand and prison numbers for many vulnerable, low-level and non-violent offenders across the community. For example, we have heard numerous cases throughout the debate today, one of which included a man who was charged with stealing less than $2 worth of petrol, then refused bail and held in custody for nearly 24 hours because the uplift provision meant he faced the most onerous bail test. The double uplift provision have also resulted in those accused of repeat lower-level offences facing the same tough reverse onus bail test as those charged with the most serious of offences, such as murder. Again, for example, a charge of a minor shop theft allegedly committed when a person is already on bail for an earlier charge of shop theft results in the person having to show compelling reason to be granted bail. This is also the same test that applies to serious offences such as rape. A further minor shop theft allegedly committed on bail then results in the person having to establish exceptional circumstances in order to be granted bail. This is the same test applied to an alleged murderer. Yet the total value of these thefts could literally be just a few dollars, and the risk to the overall community safety very minimal. Yes, of course, there should be consequences for committing a crime, and yes, of course, there should be consequences for breaching bail. But it is clear that the current consequences are far too harsh and far too broadly applied, Acting Speaker. Because when we start treating a murderer as the same as someone potentially stealing a loaf of bread just to survive, you know that the scales of justice are unevenly balanced. Acting Speaker, the approach of lumping together low-level offenders with serious and violent level offenders is not a first, however, for this state and for this country, and in fact can be traced back to the very origins of this nation's post-colonial history, and in many ways, I believe, have long continued to influence the very approach that governments have taken when it comes to crime and justice policy. Acting Speaker, let me take everyone back a little bit here. But as set out by the National Library of Australia, from January 1788, when the first fleet arrived at Botany Bay, to the end of convict transportation 80 years later, over 160,000 convicts were transported to Australia. With respect to the first fleet, there was somewhere between, depending on which record you look at, between 1,000 and 1,100 people who made that voyage. Many didn't survive. But that voyage consisted of between 750 to 780 convicts. Of these convicts, based on various records I've managed to canvass today, there were around 160 convicts who were on board who were convicted for murder. But there were also around 20 convicts who were convicted for stealing a handkerchief, 15 convicts who were convicted of stealing a cap, along with many, many others and dozens for much lower level crimes that today would be considered very much petty. But building on this era, Speaker, many know that I represent a suburb that, for an extremely extended period, for better or worse, was home to the synonymous Pentridge Prison, a place that has an extremely dark history and that for well over a century was literally the end of the line when it came to Victoria fulfilling its criminal justice policies, from the 1850s right up to its closure in 1997, almost 150 years. However, the timelines around the establishment of Pentridge are in fact quite profound when again it comes to helping to some degree explain the approach of governments over successive decades and persuasions when it comes to informing crime and justice policy. Acting Speaker, as outlined in Richard Broom's wonderful Between Two Creeks book, The History of Coburg, it was in December of 1850 that 16 prisoners were marched north by armed warders from Melbourne Jail, the old Melbourne Jail today, to establish what became known as the Pentridge Stockade, an action which forms the foundation of what eventually went on to become Pentridge Prison, which went on to become Greater Melbourne's main remand and reception prison until its closure in 1997. However, it wasn't until July of 1851 that Victoria was actually formally separated from New South Wales and was formally recognised as an independent colony. And it wasn't until 1856 when the Parliament of Victoria, this building, was actually constructed and opened. And of course, it wasn't until January 1901 when Victoria was declared a state of the newly federated Commonwealth of Australia. So, Acting Speaker, the fact is we had Pentridge before we had the colony of Victoria, we had Pentridge before we had the Parliament of Victoria, and we had Pentridge before we had the state of Victoria. And, Acting Speaker, let the record show that we had a prison before we had a parliament. And when you build prisons before parliaments, that has to have some sort of lasting legacy and influence on the way in which governments address crime and justice policy. So whether it was Botany Bay in New South Wales or Van Diemen's Land in today's Tasmania, or whether it was in today's Coburg, which largely grew and evolved around the establishment of Pentridge Prison, the fact is we are a country and a state that has been established on the dispossessed lands of First Nations people, and a country where we had prisons before parliaments. And I genuinely believe that we as policymakers have a responsibility to be fully aware of this history, especially as we increasingly turn our minds to questions of fairness and justice in this place, including when it comes to the need to modernise bail reform even today. In this context, we now know that the 2013 and 2018 changes to the Bail Act did leave some in our community disproportionately exposed to the criminalisation and incarceration. In this respect, we now understand and acknowledge that we did get the balance wrong. Reform of these laws has since been called for by several reports, inquiries and legal stakeholders, most notably the coronial inquest into the death in the custody of Veronica Nelson, which was investigated via the Nelson Inquest, whose tragic death, family and loved ones I acknowledge and express my sorrow and sympathies to. However, it was also the parliamentary inquiry into Victoria's criminal justice system which also called for reforms to bail. In this regard, I draw the House's attention to the Parliamentary Inquiry's Victoria's Criminal Justice Report of March 2022, which sets out the impacts the changes had on vulnerable community cohorts. And as stated on page 433 of the report, and I quote, "Reforms to the system that were introduced in 2013 and 2017 have had an impact on the Victorian prison population, with a significant increase in the numbers of people being remanded in custody. Importantly, the current bail system has had very negative effects on individuals charged with an offence and has disproportionately impacted cohorts such as women, Aboriginal and Torres Strait Islander peoples, children, young people, persons with disability. Indeed, the report made a number of findings that go directly to informing the reforms that are contained in this bill, including finding 37, which found women, particularly Aboriginal women and women experiencing poverty, have been disproportionately impacted, and finding 39, where Victoria's bail system must balance and maintain community safety with the presumption of innocence for people accused of an offence. and Victoria's criminal justice system does not currently appropriately or fairly balance these objectives. That's why this bill is so important, Acting Speaker, and which why I commend it to the House and support it. And in doing so, I'd like to flag my previous experience of being an advocate for young people for many, many years through the establishment of the Oxygen Youth Centre, where we literally stood up for the most disadvantaged and vulnerable young people that's there now on Gaffney Street in Coburg, which the Minister for Youth recently visited with me. Thank you.